Good afternoon, and thank you for joining us this afternoon for this, what I think will be a really terrific conversation with some super interesting experts. I'm Trevor Morrison. I'm the Dean of the Law School here at NYU, and I'm glad to be the moderator of the discussion today, today's NYU Law Forum, the topic of which is, could the internet break democracy? And as I say, we have a fantastic panel of experts to address that issue for us. Each of them deserves an introduction far longer than they're going to get because we want to get to this conversation quickly. So let me just quickly run through who's with us today by alphabetical order here. We have Randy Milch, NYU Law Class of 1985, who is the co-chair of the Center for Cybersecurity at NYU, as well as a distinguished fellow at our Reese Center on Law and Security and a professor of practice here at NYU Law. We have Faiza Patel, class of 1991 from NYU Law. She is the director of the Liberty and National Security Program at the Brennan Center for Justice at NYU Law. Chris Brigman, who is the Murray and Kathleen Bring Professor of Law here at NYU. Kara Swisher, contributing opinion writer at the New York Times and host of the podcast Sway. And Jeremy Waldron, university professor at NYU, of course, a member of our faculty at the law school. Thanks to each of you for joining us. So let's jump in. Our audience has seen the blurb describing our topic today, but perhaps, Jeremy, I might ask you to begin with describing the basic problem. Does social media promote free speech and democratic engagement or impede it? We know the premise of a lot of free speech doctrine and theory is that the antidote to bad speech is more speech. This is Holmes's marketplace of ideas metaphor. I recalled also Learned Hand's statement that the First Amendment presupposes that the right conclusions are more likely to be gathered out of a multitude of tongues than through any kind of authoritative selection. Hand said that although to many this is and always will be folly, we in the United States have staked upon it our all. So I guess the question is, does that still work? Are these ideas sound in the context of social media?
I don't know what the answer to that is. I do know that it's as though God said to us, you want more speech? We'll give you more speech. Everything that's said is going to elicit 1,000 replies. Each one of those is going to elicit 1,000 other replies, each one of which will offend somebody else. And this vast juggernaut, or to vary the metaphor, this great inundation of speech will be associated with anybody's particular intervention. And if somebody's intervention is bad speech, as we say, if it's hate speech, if it's some sort of terrible lie or misinformation or some sort of abuse of the democratic process, then there's no doubt that there's going to be plenty of speech elicited from that. But it's not clear to me, and I think this is one of the issues that we have to talk about, whether the tidal wave of tweets and Facebook postings and other things is going to really do the work that Justice Holmes thought it would do, or that Justice Brandeis and Whitney thought it would do, whereby more speech would actually engage with the original intervention and perhaps help us sort it or discriminate the sensible thing to say from the hateful thing to say, the true thing to say from the false thing to say. So I think, we have social media now largely dominating the language and practice of political dialogue, if you can call it that. But whether that's really genuine dialogic engagement, whether the mechanisms are there to allow people to hear speech being refuted or responded to, that's the problem. When we have this sort of tidal wave, this inundation of speech responses, I think what we have is an accumulation of speech. But whether that accumulation is doing any of the work that Justice Holmes imagined in this rather magical metaphor of free speech, I'm not sure.
We're going to move through a number of topics here, and I'm going to be inviting everyone on the panel to speak, but I've also told them that I hope they will each feel free just to jump in as the conversation inspires them to do. And I'm happy to open the floor here if anyone wants to add just on this diagnostic question of what exactly is the problem today?
I'll jump in. Having never gone to law school, and it looks like I'm with a lot of professors here. You've already brought in Learned Hand and Oliver Wendell Holmes, so I'm screwed. I think that I think you just have to go from what Jeremy was saying is that this is is unprecedented amplification and sort of weaponization of speech in a way that's never happened, combined with an ability of anybody on the planet to use these very easy to use tools, which have been evolving and continuing to become easier to use and more prevalent across the world. Into something that has resulted, unfortunately, in more weaponry than tools. I think it was started as tools, and Brad Smith from Microsoft has written a really good book about this, is that you can look at a knife as a tool or a weapon. Most of these things are now being weaponized by a lot of malevolent players and individual players for a variety of things. And that's unfortunate. It's sort of as if everybody has a nuclear bomb, essentially, across the world and can lob it at any time. One of the problems that we have, that I've covered it since the very beginning, and I was one of those hopeful people that we could create sort of this Star Trekian kind of future where we all talk to each other and we go explore and we have a little fights, but eventually we all hug at the end. And we've kind of moved into a Star Warsian kind of, I'm going to use my great legal background in this way, which is cultural interest, where it's dystopian, where the Empire strikes back, where the Empire often wins and even the winners sort of lose and die. And so it's going to be, it was the problem at the very base of it. And maybe you all, I'm not an antitrust expert, I'm not but I am a student of power. And one of the problems is that a lot of this has been done in the private sector and being run by people who are wholly incapable of dealing with the problems ahead. And you have a government that is completely divorced itself from any responsibility in either regulation or anything else in this whole things, in this entire time, in this 25-year time period since I've been covering it. Very little government intervention, and actually government rules actually protect these companies really significantly. And so that's the question, is there's been an absence of government oversight, a concentration, increased concentration in private companies run by people who are the richest people in the world, running the most valuable companies in the world. And there's been no kind of regulation to speak of. And they've been foisting essentially an addictive, problematic, unregulated, just a system on everybody. And it's gone wild. So.
Yeah, Trevor, I have to say I'm much more skeptical of the weaponization argument, not because I don't think it's happening, but because I think it's always happened. So I remember when the New York Times weaponized speech against Wen Ho Lee before social media. I remember when the New York Times weaponized speech to cause the war in Iraq or to help cause the war in Iraq. The difference is that with social media, it's no longer only elites who are able to weaponize speech. It is everyone who is able to weaponize speech. Some people are kicking up, and that makes elites very uneasy. I never think, I think the marketplace of ideas metaphor was always a bad metaphor, and it doesn't really work that way. It's never worked that way. The difference, I think what's really driving this now is not speech or the absence of government regulation of speech. That's always been the story. I think what's driving this now is more people being able to speak, and also, frankly, the consensus of liberal democracy breaking down at such a wide scale that there's more at stake in the speech. So, a lot of this, Section 230 will talk about this notion of kind of reforming our First Amendment practices. I think these are all valid conversations, but I think underlying all this is the fact that politically Americans are increasingly split into hostile camps. They stand at daggers drawn. And this has not been the truth in America since the Civil War. So, I think a lot of this conversation is kind of riding uneasily on the surface of something much greater.
Just so you know, I don't work for the New York. I am actually not an employee of the New York Times. So if you want to do New York Times bashing, go ahead. I purposely don't work for anybody because I am one of these proponents of being able to have voices all over the place. But it's not an elite thing. I think it's actually sitting on something bigger. But look, Hitler didn't need Instagram, right? And neither did Mussolini, didn't need Reddit, and other malevolent players over the course of history haven't needed any of these tools. And that's absolutely clear. But what's harder here is how big and how vast and how massive it is in the ability to reach people. And that is a very different thing than anything that's ever happened. Sorry, sorry, go ahead.
No, that's helpful. And I think just as framing, there's a question that Chris is, I think, sort of pressing back on, which is whatever the concern is now, is it actually a new concern? Or is there more continuity with sort of how things have been, or whatever the concern is it really about social media, or is it about something else, about the state of our polity, of our democracy? I know that Randy wants in on this, but I want Faiza first to see if she might just help us to the extent that there is concern along the lines that Jeremy and Kara have described. I think it might be helpful if we try and specify it a little bit more by talking about, are there particular groups of people, are there particular kinds of ideas that are most at risk of harm in the way speech happens on social media today? Faiza, what would you say to that? And then to Randy.
Sure. I mean, I think that's exactly right. And I think everybody's sort of getting at different aspects of the same thing, but people are weighing the harms a little bit differently. And I think that when I look at this issue, I look at who are the people whose speech is actually being the most impacted when social media companies act to remove speech or to downrank speech. And I think we don't really know the answer to that, because the kind of information that we get from the social media companies is kind of raw numbers, right? But one thing that we do know is, one of the things we've been looking at is the difference between the way the companies treat what they call terrorist content versus how they treat what they call hate speech. And in very broad terms, when you're talking about terrorist content, we have, for the longest time, only talked about ISIS, Al-Qaeda content. We're not talking about the Proud Boys or any of that kind of stuff. Kind of like the counterterrorism laws, actually. That stuff gets taken care of under hate speech policies. And when you look at the contrast between those two, you notice right away who are the populations being affected. By the stricter terrorist content policies, you're looking primarily at Muslims, Arabs, South Asians, brown people writ large. And when you're looking at the hate speech, you're looking at populations that are mainly white. Not always, but mainly. And both the rules for hate speech are far more flexible, far more nuanced, with a lot more loopholes and a lot more tiers about things you can and can't say. Whereas when it comes to terrorist content, it's just out. It doesn't matter if you're saying that, maybe al-Awlaki was nice to dogs, like it's just out. So I think what you see over there is, in fact, the power disparity. And I think recently a Twitter employee said it really well. It was like, well, when we were taking down Muslim speech, nobody cared that much. But now that we're taking down the speech of people who are closely aligned to the Republican Party, people are much more worried. So I think as we think about this issue, we also have to think in really real terms about whose speech is getting suppressed. And I just want to end with one last thing, which is nothing is new in some sense. These voices, the voices of sort of minority communities often push back against free speech arguments, because they say, well, that's all great, but our voices were never being heard when we were in a sort of free speech paradise either. So you're basically seeing a continuation of that, but just sort of adapted, I think, to this new milieu.
So Faiza, you brought in a really interesting dynamic. So one diagnosis of where we are, and I think I heard both Kara and Jeremy emphasizing this, is this sort of kind of Wild West nature of this speech on social media that is, as Jeremy said, is just an inundation by volume. And that there isn't a presence, Kara is saying, of government, and we should talk about regulatory options, et cetera, in a moment, I think, and 230 may be a part of that. But there's the other side then. You're actually talking about right now, like what does law and what does some private actors' own policies tend to produce in terms of exclusion of speech, in terms of censoring. So those are almost the opposite kinds of problems, right? But if they are both phenomena of where we are, then there's a kind of absence of dealing with trying to control this otherwise uncontrolled Star Warsian situation, and some form of censorship going on, that both are happening at the same time. Are they both aspects of the same problem? Are they different problems? I'm not necessarily posing that just to Faiza, it's just a question I have.
Yeah, I think that, it is really important when talking about social media to sort of try and separate out the different strands of the issues that we're talking about, because we have a tendency to lump everything together. We talk about misinformation and hate speech and, all of this stuff in the same breath in a way. And in some sense, the platforms encourage that because their policies are very overlapping, right? So, whether they're taking down a piece of content on the basis that it's violent or whether it's terrorist or whether it's hate speech, I mean, you're kind of mystified as to what's going on over here. So I think it's important to parse these different aspects of the issues of social media and keep in mind that as we think about regulation, I know we're going to talk about it later, particularly regulation that impacts speech, we have to think about, well, which way is it going to go? Because generally speaking, regulation will benefit those who are in power, even when it is meant to kind of control this environment. So I would be really cautious about how it affects minority voices.
Sure. Randy, do you want to enter here?
Well, I feel like FISA has taken our conversation in a good way, well beyond what we were talking about. I do want to round one last aspect of the marketplace idea of ideas, which always, whenever I read it and understood it, it was really about a preference to the alternative. And the alternative is the government doing this, which gets us a little bit back to FISA's point that she just raised, which is the dangers of regulating in this space, and the problems associated with the government deciding what truth is. If we're going to put a premium on truth in conversation. If you're going to assume that answerability is an important value, I don't think the First Amendment's ever depended on answerability as being an actual precondition to the application of the protections, right? There's plenty of case law that shows that, that for instance, state law prohibitions on op-eds, on editorials on election day, right? The reason that the state law was against it is they were unanswerable, but the Supreme Court struck those down as not being, the unanswerability did not defeat the application of the amendment. So to me, it's always been a question of the preference of the marketplace, which I took to be the preference of having there being sort of tooth and nail fights over the government interceding here and picking winners and losers in it, and the government will do a job that we will hate very quickly, I think. That is sort of the opposite here. Not really the failure of the marketplace of ideas was never. I mean, the quote you read us from Learned Hand presupposed its failure. Mm-hmm. Right. And so, but as he said, we've staked our all on it.
Jeremy, do you want to enter here? And then I want to ask about Section 230. I'll turn to some combination of Chris and Randy to orient us to that. But Jeremy, you first.
Yeah, just very quickly, because I think you're absolutely right about the dangers of state intervention. There's one thing I've learned from the 8-year career of the Harm and Hate Speech book, that people are highly suspicious of any legislative intervention. But it isn't an all or nothing thing, and it isn't state or nothing. The question is, are there landmarks? Is there sufficient monitoring of the possibility of engagement? Can the mainstream media, either the television media or the newspapers, play a role of some sort of filter or facilitating some sort of engagement? Anything other than this tidal inundation. And it seems to me that although I entirely accept FISA's concerns about who gets excluded, some of the powers that are protected by Section 230C2 in the debate that we're going to be talking about in a moment, some of those powers act as brakes or act as ways of just ensuring that it's not just a cacophony of people shouting at each other. If there's going to be any engagement, and I'm very, very pessimistic about it, if there's going to be anything remotely resembling a marketplace of ideas, there has to be deliberative engagement. And doing that without any signposting, any monitoring, any form of breaking seems to me to be seems to me to be hopeless. So I hope we can talk about these other forms of structuring rather than just government repression as the possible alternatives to the marketplace metaphor.
Well, I think might be quite a nice transition into 230, because in a sense, one way I hope Chris and Randy can help us think about is what's the relationship between what a legal instrument like Section 230 does and the prerogatives that a private platform like Twitter or Facebook therefore have to make some decisions around content, where they would, that's not literally the state. It's very, very, very large and powerful private organizations making decisions. And perhaps, there's a question of whether they could be providing some of the signposting that you're referencing, Jeremy. But capacity to do that, I think, in light of the current regulatory space, requires that we understand what this Section 230 is, which I feel, at least as not an expert in this area, has been kind of waved about like a bloody shirt over the course of the last 6 months. And I think the percentage of people saying the word Section 230 who have any idea what it provides is distressingly low. So I'm hoping, Chris and Randy, you can fix that for us and our audience.
To liken the debate over 230 to a bloody shirt is to insult bloody shirts, actually. So 230 is actually shockingly simple if you strip away the arguments about it and just look at it. The main part of it is literally 26 words, which are: no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So to boil that down even further, Section 230 gives online service providers like Facebook or Google immunity for third-party content that is posted to those platforms by third parties. Section 230 also protects online service providers when they act in good faith to remove content that they find to be obscene or threatening, harassing, otherwise objectionable. Even if that content is constitutionally protected, the service provider is shielded from liability. Now, what Section 230 doesn't do. So Section 230 doesn't apply to federal criminal liability. It doesn't apply to electronic privacy claims. It doesn't apply to violations of federal and state sex trafficking laws. And most importantly, it does not give online service providers immunity for content that they themselves produce. Okay, so people say all the time, well, doesn't this give online service providers immunity that the mainstream media doesn't enjoy? It's actually a little bit more complicated than that, because here's an analogy. So Facebook has immunity against stuff that you or I post to Facebook. It's third-party content. Just like Comcast typically can't be sued for stuff that Fox News says. And let's be clear, I mean, people are focusing on online, but the biggest disinformation source is Fox News, is OANN, is Newsmax, but Fox News, above and beyond everyone else. They spent a lot of time spreading malicious lies about the election. They're being sued by the election machine companies that they defamed, right? So this is, a whole part of the ecosystem that we're not really talking about. But Comcast is protected against Fox News's content in much the same way that Facebook is protected against liability for your content and mine. So why are people against 230? I'll just finish up by saying this. It's both from the right and the left. The left is against it because they think that online platforms are a vector for political disinformation, for harassment, for hate speech. And what I can say about that is, 230 basically gives online service providers immunity for that. But on the other hand, if we remove 230, the First Amendment is still there. So unless we radically rethink what the First Amendment protects, a lot of what 230 does is just going to be done at much higher cost than making a lot of lawyers rich by the First Amendment. Now, the right hates it because they allege that these online service providers discriminate against conservative views. And they point to, for example, Twitter deplatforming Donald Trump, and Facebook then too. And they point to Google and Amazon essentially disabling Parler. And my response to that is, there is no good evidence that any of these services are discriminating against conservative views. There is actually very good evidence that conservatives are disproportionately responsible for spreading both online misinformation and hate speech. And so, in a sense, they are reaping what they have sown, and they are complaining about it. So that's the debate in a nutshell, at least from this perspective.
So can I just jump in? I was around when it was actually, I wrote about it at the Washington Post when it was first put in place. It was part of a larger bill, the Communications Decency Act, of which
Right.
Fawn Hall was involved. It was all kinds of mess, it was a hot mess, that particular law. But the idea of it was Prodigy and CompuServe, which were two different companies you have forgotten about completely now. CompuServe was a kind of a Wild West, and Prodigy did a lot of content moderation, which I was welcome because it was a cleaner platform essentially. And CompuServe was, that version of Reddit or whatever is you want to call right now. And it was done so that these companies wouldn't spend their life in legal jeopardy, essentially, constantly. And so it was really at the time meant to allow this industry to grow up in a way that would help them in some fashion in order to avoid some of the more persistent problems, especially around pornography. There was all kinds of things at the time around gay issues. It went on and on. And so it stopped them from being sued into non-existence, which was a very good thing, which I think most people can agree. I think the issue people have around it is it then put all the content moderation in the hands of private companies and not anywhere else. And that's where it sort of belongs, just like it is in regular life. And that's where we have had the biggest problems. What Chris said about the right saying that they've been silenced is laughable on so many levels. I mean, they never shut up, actually, is what's really fascinating about it. But one of the things that the problem it faces is if you remove 230 the way a lot of people, both on the left and right, have talked about, they will content moderate themselves out of existence. And that's really the issue, is that people that just talk about it, let's just sweep it aside, let the lawyers go run. There is a good, and you all would know better than me, a good argument for more liability on behalf of these companies, because they become not just platforms, they're publishers too. So they call themselves platagers sometimes. What if this gets thrown out the way that people talked about kind of sloppily, nothing will appear online. They will take everything down. And so, and why wouldn't you? And so I'd love to understand better from a legal point of view why you wouldn't take things down.
Yeah, maybe we can just, let me, just to jump in, to concretize that, because I think, a lot of the sort of the visibility of Section 230 to many across the country seems to have sort of coincided with the deplatforming of Trump from Twitter. And his accusations of Trump's particular sort of attacks on social media platforms and on 230 seems to be based on a premise that in the absence of 230, deplatforming decisions like that would be less likely to happen or more risky. But isn't it the opposite? Isn't it that
in the absence of 230, they would have thrown him off of Twitter years ago?
Yeah, just to spin that out, because it's at that point, Twitter would be answerable for the potentially defamatory or other liability triggering content of Donald Trump's speech, right? And so their lawyers would advise them
it's
to
more than that, because most people would say if they threw Trump off Twitter, okay, but Me Too. Okay, so there are women online on Twitter elsewhere saying, this powerful person in Hollywood sexually assaulted me. All right, so imagine without 230 what the cease and desist letters would have looked like going to Twitter, to Facebook, et cetera. So Me Too, I don't know. I mean, it's hard to say counterfactual, but it's at least imaginable that Me Too wouldn't have gotten off the ground but for those liability protections.
I know Faiza and Randy want to jump in here. Faiza, you, and then Randy.
I mean, I guess there's also the question of the second part of 230, right? Which basically protects the companies for doing content moderation. So if you take away that part, you're basically, going back to the pre-230 situation where they're fighting every case on the merits of whether or not, there's a First Amendment right, et cetera, et cetera. But I also want to just ask a quick question, Chris, which is, this whole publisher platform distinction, which we talk about all the time. I understand obviously that Facebook and Twitter aren't creating content, but to some extent they're creating the feed and they're creating what we see. Their algorithms are deciding which pieces of information to elevate and which pieces to downrank. Doesn't that count as kind of like creating something?
Well, the courts have said no. The courts have said that those are standard. That's not any different than the New York Times just deciding what's on the front page and what's on the last page. And have likened it to those sort of publisher decisions. They've limited contributing to the content, which would take you outside of the safe harbor, to substantially contributing to the content, and not simply making a publisher decision on where it happens. So the courts have been through that, and they've decided generally not. I tend to agree with Trevor that I think that the absence of 230 would result. So the first part of 230, as Chris says, sort of protects the platforms from under screening, from making too few screening decisions. The second part protects them from over screening. That is a lawsuit for taking down too many things. The jurists recognized almost immediately that in that situation there would be a tendency to underscreen, right? Because there's no downside to underscreening in that tendency. But as Kara pointed out, the original set of lawsuits that prompted Cox and Wyden to come up with this solution when they were in the House was, on the one hand, Prodigy, and the other hand, CompuServe. Cubby v. CompuServe was the parallel case. Everyone talks about Stratton Oakbot v. Prodigy, but Cubby v. CompuServe was CompuServe's defense to the exact same sort of lawsuit was, we make absolutely no distinctions about what happens. You bring it up, you put it on the board, it's fine. We are like a newsstand, and we have no liability for these things. Now, newsstands actually do eventually get liability if they're put on notice. So there's a question about what happens eventually in a notice regime. But, I think that the first blush might be, if we're faced with only the First Amendment for protection, we're going to opt in for zero moderation. The problem with that, of course, is, as Kara also pointed out, people don't like that. Mm-hmm. People don't necessarily want to be on that platform, right? And maybe people will vote with their feet a little bit if that were the case. I mean, we've always faced the problem for years, back when I had a different job, the fact that the internet's a cesspool. I mean, the internet's been a cesspool since 1993, because everyone recognized that the most important thing on the internet was sex. So the most attractive thing on the internet was sex, I guess. I don't know, not important. I didn't want to give it a qualitative view, but it's always been a cesspool. So people can make their determination about how they want to play in that cesspool. But I think that with only the First Amendment, a bigger cesspool is a more likely effect.
Right. The trouble is, if you associate the cesspool image with the inundation image, and ask what
Florida.
Ask what the effect of that on democracy is, then I think you've got a serious problem.
Yeah, but the truth is, it's not only a cesspool. I mean, this is what we tend to forget. So, I had a student when I was at UVA who wrote this really wonderful article in Slate last year, where he talked about, so people point at Reddit and they say, oh, Reddit's a cesspool. Well, when he was a young, Black, gay conservative figuring out who he was on Reddit with other people figuring out who they were, and not just Reddit, but also Facebook and other social media sites. And, he was forming a community, he was forming an identity, all this stuff, that what makes this problem so difficult is, if it were only a cesspool, we're talking about a relatively easy problem.
Yeah, one of the things is Reddit's actually done the most cleaning up, and the CEO, I've done a lot of interviews with their CEOs, they've done the most active use. And one of the things he just recently told me, his name is Huffman, I'm losing my mind. What he was talking about was that they decided to take down malevolent cooperators, meaning people who pretended to cooperate, and follow the rules, and then just didn't. And he just decided to take them down because it's about community more than anything. And so what's happening on Reddit is actually a lot better, and it's kind of an interesting system. The problem Reddit has, and he's talked about this a lot, is they have a lot less money to do the kind of content moderation possible. And there's story after story about content. There was just one today about content moderators at these various social networks dealing with this on a constant basis, whether it's child pornography or whatever sickness is at the heart of too much of humanity. It's an incredibly difficult thing. And many years ago, I had a conversation with Mark Zuckerberg where we talked about this. I was like, this is going to be, besides the Russia issue and the malevolent players we talked about, I was like, you've got to figure out some way to moderate this in some way. I'm not really clear how you can do this properly. And he had placed his hands in two areas. One was community, which is really hard, which is we're painting his fences, the richest man in the world's fences. Thank you very much. And the second one was AI. They had hoped that AI would be the big solution. He talked about it incessantly at the time. And it just isn't. It just doesn't. It creates all kinds of problems. It has all kinds of issues. It really is a black box in many ways. And so one of the problems was that there's no, and then when you put people on it, you get all kinds of mental issues. And they've tried wellness, they've tried psychologists, it just doesn't work. When you're looking at child pornography and beatings and really gross stuff all day, you get to be that way in a lot of ways. And so the problem is there's no really good solution to it at all whatsoever. And that's the problem we face. And let me just say one other thing. You're talking about the Donald Trump issue is he broke the law more times. I don't know if what an analogy it is, but he broke that law the laws of Twitter so many times. They were well within their rights of tossing him off well before that. Well, many, many times. And when it got to the bright red line, which is incitement to violence, that's where they finally decided they didn't want to be handmaidens to sedition. They felt like that was probably a step too far for them. What was interesting about that is if you may agree with the decision that just two people made, Mark Zuckerberg and Jack Dorsey, the fact that just two people made it is the real issue. It's about power and concentration that is only solved by innovation and ability for new companies to bubble up and not create these monocultures of social. There's not been a new social media company that's been particularly powerful since Facebook. There's not been a search company that's been powerful since Google, excuse me. There's not been a real, whatever Amazon says, they dominate the commerce space. And so that's really where the push-pull is the amount of power and power concentration, which both Republicans and Democrats, the right and left, should be joined on, because every one of their problems will be solved when you figure out the power problem that occurs here, in my estimation. So 230 is kind of I don't think anything should be done to it. We should really focus on taxing, fines, power concentration, antitrust when it's applicable. And then the last thing is we always talk about big tech. It's ridiculous. There's no such thing as big tech. There are big tech companies, and each of them presents a different problem, some of which are more significant, some of which are not, or able to deal with on a much easier way. And if our legislators understand anything, is that they should use 20 different tools to deal with this, one of which is antitrust, which again, I'm not an expert, but it's the last tool I suspect that's going to work very effectively against only some of these players.
If I could just jump in, I think that, the topic of this is social media breaking democracy. And I think on some level, what Kara pointed out is two guys basically shut up the president of the United States. Much as you may hate him, that's pretty anti-democratic as well. But we don't think about it that way. And notably, they only really shut him up when they thought he was going to be, he was sort of at the end of his time. I think there's a little more than a little coincidence that they had 4 years of extremely terrible behavior, and they just let him be on there. So I think that tells us a lot also about the power play and the democracy point over here.
As we think about how to address this problem, if it's a problem, to Chris's point, yeah, it's not all one big cesspool. If it were, then that would be a different kind of solution. But I think one way to think of the problem, as Jeremy and Kara were describing at the beginning of our conversation, is there's something about there's a growing sense that the net mix of benefits and costs of this arrangement is not the same as when Holmes was speaking or Hand was speaking. So then the question is what to do about it. And to Randy's point, it's not that we should love the marketplace of ideas. It's just that we should be a lot more concerned about basically any other alternative. So let's talk a little bit more about what some other alternatives would be. And one that's been raised recently by the likes of Justice Thomas in an opinion in a recently decided Supreme Court case, is that perhaps these social media platforms, to Kara's point, I don't know if he's talking about all of big tech or particular social media platforms, should be, regulated as a common carrier or treated like a public utility of some kind. So just descriptively, Randy, can you help us understand what that would mean?
I'd like to hear that. Someone explain that to me, because he's the world's expert on technology, that guy. When he speaks at all.
So I would point out that these were decidedly loose musings in a concurrence to a denial of certiorari. So
Right.
it's hardly a
Full briefing and argument. Yeah, right.
And there have been some pretty unhinged responses to the musings. But if you, the whole notion of treating these creation of something now called a speech utility, I guess what we would call it, or a speech common carrier, raises a lot of interesting questions. Historically, the common carriage, the attractiveness of the common carriage rules it seems to arise on the conservative side in particular, because there's a feeling that the common carriage rules forbid discrimination, forbid some sort of discriminatory effort on the part of the carrier, right? They are open to all, they have to serve everybody, and there's so-called limitations on the power to exclude. And that is, I think, what makes it attractive. So it's a way to rethink the second part of Section 230, the protections for over, over screening, if you will, by saying that there's some sort of inherent limitation, and this is a venerable limitation, right? This is 400 years old, so it should be regarded with great respect. And the problem with comparing the speech platforms or creating a speech common carrier with the traditional common carriers, the traditional public utilities, is that the public utilities, the theory arose from the inability of the public to utilize other means for accomplishing the ends, right? And so they intended to be things like a bridge, a barge, railroads where there were no other railroads, public communication, telecommunications companies, where I am quite familiar with common carriage, because society decided it was basically inherently inefficient to have competing communications carriers in the same location, right? You wouldn't ever, as a matter of public policy, want thousands of lines going all these places. It's far too expensive. So the outgrowth, though, of this common carriage notion is deep government involvement, and that is the great problem with this theory. A common carrier is, first of all, governed by their tariff. So you can analogize that to the terms of service of a platform, say, or the authorized use policy. And some of the very interesting suggestions for how to modify Section 230, one of them, the PACT Act, actually sort of takes on this approach of saying there has to be an enforceable term of service, right? The problem is that a common carrier's terms of service, its tariff, is approved by the government, right? And the government is deeply involved in ensuring that the common carrier adheres to its tariff. Secondly, a tariff does not in any way forbid discrimination. It just forbids unreasonable discrimination. That's what a common carrier can't do. It can't unreasonably discriminate among its customers. So it's free to discriminate. You just get into the question is what unreasonable. And finally, part and parcel of common carriage is a wide range of protection against lawsuits. In fact, I went back and I actually went on the internet and pulled up Verizon's local tariff in New York. It's tariff number 15, which back in the day, I think I directed someone to file. And the Verizon New York is indemnified by its subscriber for claims for libel, slander, or infringement of copyright for material transported over its network. It's not going to be liable for any of that. It's indemnified against all other claims arising out of any act or omission of the subscriber. right? It has the ability to terminate service and thus exclude, if you would, if it were a speech carrier, in the event of prohibited, unlawful, or improper use of the service, right? And it defines improper use as things like using profane or obscene language. So the next time you're moved to curse over your telephone, if any of you still use landline telephones, please don't curse, because you're liable for immediate termination of your service because it's a prohibited use. I don't think that the common carriage approach, which is attractive, as I say, because it carries with it some limitations on the ability to exclude, makes a heck of a lot of sense in this, predominantly because it so involves the government in the everyday actions consistent with what the carrier does.
Jeremy, did you want to weigh in here?
Yeah, I just wanted to ask Randy whether there's anything in the common carrier framework, as Justice Thomas envisages it, which would go beyond questions of exclusion and inclusion, but would go to questions about quality, and particularly quality of interaction facilitated by the network. You know, we used to say that certain television channels had to have content of a certain kind, educational programs. So we got these ludicrous things about UFOs landing in Mexico, and that was the
Fairness doctrine too.
Huh?
The fairness doctrine you're talking
Yeah,
about?
the fairness doctrine as well. But whether there's anything of that qualitative sort for the common carrier approach, and if there isn't, whether there are other, again, metaphors, frameworks for thinking, because if we're trying to bring this back to democracy, we still have to wrestle with this problem about how is the basis on which opinions are being expressed, amplified, and disseminated related to the process by which they might be brought into relation with each other deliberatively and critically and evaluatively. Recently, Twitter started a practice. I know this because before the election, I was a frequent tweeter. It started a practice when you wanted to retweet something. The mechanism would say to you, before you retweet this, do you want to read it? And you would say, no, I want to retweet it anyway. But that looked like a futile,
That's the Are
tiny.
You Drunk thing. There used to be an app where, are you drunk? Do you really want to send this text?
That's
here?
right. It was the same for drunk text.
Thanks, Mom. No, none of your beeswax.
Yeah, I think, Jeremy, you're not going to find it there. There's certainly the government always arrogated unto itself the ability to tell a common carrier that it had to include certain quality metrics, mostly as a consumer protection benefit, because again, the feeling was that the consumer of the utility had no choice, and therefore the relegating some ability for the government to say you had to do certain things made sense. Absent that, the carrier is held very strictly to the quality perspective, the quality metrics that it puts out in its own tariff, right? So to the extent that the carrier wants to make a claim about quality or something like that, it's held strictly to it, both above and below, right? You can't go. One of the perverse aspects of the common carrier is you can't do better, right? That's also forbidden. You're held strictly to your tariff obligations. I don't think you're going to find the signposts that you're looking for there. And we could, Trevor, if you wanted to talk about some of the reform of Section 230 ideas, because there's no shortage of reform ideas.
Before you say, the whole idea of doing this is ludicrous. It's not happening. It's just not. It's so complex and so ridiculous that it's kind of silly that we listen to him anyway on this particular topic. But fine, he can just bring up anything he wants. What's really interesting is actually when Facebook was founded, I spent a lot of time with Mark in the very early days, and he kept calling the service a utility. He actually did call it a utility at the time, largely because he was competing with the more sexy MySpace, and he was dull. And so he's like, we're like a utility. They're like a party, and we're like a utility. And so I think he was using it, as he does many words, incorrectly. But that was his envisionment of it as I think he meant useful versus fun. Kind of thing is what he was going for at the moment. But the idea that they're going to be regulated, it just doesn't, it's not even, again, these things are solved by innovation. These are solved by the fact that someone's going to knock Facebook's block off. And so we got to get Facebook out of the way so there's more social media sites and not allow them to strafe the landscape by buying whatever they want. And again, we faced this issue when it was telcos, when it was oil, when it was cars. It just goes on and on and on. And I understand concentration always happens, but this is unprecedented concentration among a very small group of people who are wholly incapable of making, not to insult their intelligence, they're all very smart, but good luck. And then they give us things like the Facebook Oversight Board or whatever that is. It's like the UN except 100% less effective. Just there's no solutions here. And so, but adding the government into this and a utility concept, it feels disastrous as an idea.
I've wondered whether and I don't pretend to know exactly what Justice Thomas had in mind when he seemed to endorse, as Randy says, in a posture that was something less than full briefing and argument on the issue, this public utility concept. I've wondered whether, to Kara's point, that words being used in ways that depart from what they actually mean, whether it's a more simplistic idea. Is it just like, could a public utility kind of idea give us a mechanism or a metaphor for thinking of
public square?
Private
public square is how they tend to look at it, but they're not public squares.
Well,
They're not public squares. That is the real problem, is everyone's decided they're public squares in their mind, including the right and the left, and they're not public squares. They are private squares run by the richest people on the planet. So that's where those are the kind of things. Public square is the one that I find most used, and you wouldn't do this in a public square. I'm like, well, it's not a public square, so it doesn't.
Let me play out the way they could be rendered such. So in a different area of law, sort of equality norms, right? Public universities are subject in their admissions decisions to the Equal Protection Clause of the 14th Amendment. And they therefore, if they wish to, let's say, consider factors like race in their admissions decisions, they need to be able to defend that with reference to what the Supreme Court has said about the extent of permissible consideration of race and impermissible consideration of race in admissions. None of that applies by its terms to the admissions decisions that Harvard University or New York University or other private actors make, but there are statutes that do govern private institutions, Title VI, for example, that contains a prohibition on discrimination on the basis of race that courts seem to have treated as meaning roughly the same thing as the Equal Protection Clause. So the question then, and let me set aside for the moment whether it's realistic to suppose that the Congress would legislate in this way, the question would be, is it worth thinking about causing the Facebooks and the Twitters of the world to be subject to a First Amendment norm that is not literally the First Amendment, since they aren't state actors and therefore aren't regulated by it, but they could be held to the substantively same standard legislatively. And I just wonder if that's what Justice Thomas means. When he says make them a public utility, he means make them subject to the norms that the government is subject to with respect to controlling speech.
I don't think that's what he means. I think he's watching Fox News or something.
Oh, okay.
That's way more sophisticated than I think what he means. What you mean is, why don't we legislate a First Amendment norm? But that doesn't get to the problem that he's concerned about. He's concerned about the right-wing lens, which is discrimination against viewpoints. And from the perspective— The First
Amendment would do that, right? The First Amendment would do that.
Right.
You think so?
Expose Facebook to a First Amendment norm, that reinforces Facebook's ability to discriminate against viewpoints, right? They're not the government, they're a private actor. So what do you have to do? You have to say that Facebook is operating essentially as a kind of state actor when they discriminate against viewpoints. And is that going to pass muster? Is that going to be, that? So there's public accommodations laws, right? So those, are, I guess, constitutional because Congress is enforcing through Section 5, the 14th Amendment. So what's the argument that they have similar power to enforce the First Amendment through some kind of congressional action?
So I mean, this is what further into the constitutional weeds than our audience may want us to go, but the federal non-discrimination laws that apply to places of public accommodation, these are privately owned restaurants, hotels, and the like, were not upheld under Congress's power to enforce the 14th Amendment. They were upheld under Congress's power to regulate interstate commerce. And I think the same head of authority would be invoked by my hypothetical Congress that would say, we know that Facebook isn't the state. We know that's not the public square, but we think the fraction of speech that matters to people that's now happening on these private platforms and the magnitude in terms of economic power of these platforms is so big that they are kind of like states in certain ways. We're not going to make the First Amendment literally apply to them, but we are going to prohibit them from discriminating on the basis of the content or the viewpoint of the views expressed on their platforms, just like the state would be. Maybe that's
Well,
not.
You could just remove the second part of Section 230, right? And wouldn't that accomplish exactly the same thing?
Right.
That's my question.
That's going to drive us in the wrong direction, I think.
Yeah.
Okay.
I think that's
I
going to
hear
make
more about that
the
because I think when I hear non-lawyer members of my family sort of talk about free speech being at stake with respect to Twitter and Facebook, I think what they're meaning to say is if the government's not allowed to discriminate on the basis of content, should we impose that rule? Now, that's not going to address Jeremy's concern with the inundation and the cacophony. It's liable to
it's going to explode it.
As legally required. But is that worth thinking about? Is that a reform to 230 that's being pushed?
I doubt. I mean, look. This Supreme Court with its speech views, I doubt that statute would be upheld. I do think there is something about public accommodations laws where there is a kind of common carrier, feel to it because these hotels and they're kind of, especially at the time, they're what's available, and there is the notion that there's this equality norm that Congress is enforcing, and the courts hitch it to interstate commerce, but there is Section 5. There's a sense like there's ground for this. I don't see the same kind of ground for government to say to private actors, you can't discriminate on the basis of viewpoint. Is the next thing that the New York Times can't discriminate on the basis of viewpoint, that Fox News can't discriminate on the basis of viewpoint? Why, in fact, would you single out Facebook if Fox News is every bit as baleful when it discriminates based on viewpoint?
Yeah, they're just not bigger. They're just smaller, is really. They still have resonance, by the way. They're just smaller in terms of impact. One of the things that you haven't talked about is all the other remedies.
I don't think that's true.
Well, they're smaller in terms of viewers and users.
Yeah, but they lie more. And the people
that's different. That's different.
Lies.
Purposely lying versus just letting lies run rampant on the platform, I think is what you're talking about. But one of the things that's really interesting is that there's so many other ways to deal with this that doesn't drag into it. One is taxation. There's a way to tax online advertising, which is always effective, and then use that money for media literacy, election fraud literacy, all kinds of stuff, and which I think would be fascinating. And Amy Klobuchar is working on some of this idea of and then funding the agencies like the FTC and the Antitrust Division of the Justice Department at more levels, because the amount of people and lobbyists and lawyers and PR people that these companies have is really, I mean, if you look at the statistics, it's all tech people now owning lobbying in Washington at this point, much more so than other players. That's one way to do it, is taxation. The other is fines, which they haven't really, they've been small.
But fines for what?
Well, like, for example, the consent decree that Facebook agreed to with the FTC, they gave them just different things. They've got to, of course, create regulation around, and then I was getting to the third thing, which is creating really robust privacy and data legislation that will actually not take care of this, but really start to really put some parameters around what they're doing that has nothing to do with how they use the information, how they manipulate it, what they're allowed to sell. What's really interesting is that it's Apple this next week that's going to be imposing one on essentially Facebook, but all the others through this transparency part of their new software delivery, which is you have to opt in to being tracked and stuff like that. It's a very small thing. It's quite controversial. Facebook's crying as if, Tim Cook kicked them in the nuts. I don't know, but nonetheless, it's one of these steps that you attack them economically. One is to break them up in some way or allow more innovation. The other is to tax them, and the other is to put something in place for their business model, so it's not quite as oriented toward doing what it's doing. And to me, trying to figure out this speech thing is going to be, you just get caught in this situation that's not solvable whatsoever by any government agency that should be allowed to do it because of the First Amendment.
I
And I think
find
Kara,
that-
sorry.
I'm sorry. Go ahead,
No.
Faiza.
Oh, I was just going to say, I think I think Kara's absolutely right. I think people have come up with like lots of different ways to try and solve the content moderation puzzle, and nobody really has come up with a good solution. And everybody complains about it all the time from all parts of the political spectrum. So you have to sort of start to look at other ways, in essence, of kind of reducing the power of these players. And I think, the US needs a data privacy law anyway. It's like, just a good thing for us to have as Americans. And I think it will reduce both some of the political valence of these platforms when they're not able to target, like micro-target segments of voters in the way that, both Democrats and Republicans have done over the last several elections, but also, sort of pull them away from this eyeballs kind of model that they're so addicted to, and which I guess we are too. So
I would respectfully disagree. I think that the notion that you're going to be able to tax and tax these people into any meaningful difference in their approach is ridiculous. I think that the notion that you're going to tax them and then Amy Klobuchar is going to decide how we're going to educate ourselves to prevent this is silly. And I think that the notion that just because the government's going to be doing it and the government's not going to have any idea how to educate us about this, about how to be better citizens. I mean, it's not the first time that we've had these problems. And finally, I think that while I very agree that we need a data privacy law and there needs to be better cybersecurity, I'm all for all those things. I think Google's already demonstrated that it's moved past the notion that it needs to retain any data and look at any data about any particular customer in order to be able to target ads with the same sort of accuracy as if it had. It's already moved past it.
Yeah,
so
exactly.
All those rules are going to be fighting the last war, which is what always happens when the government decides to go after a company. They went after big oil. We still got plenty of big oil. And when they went after big oil in the early parts of the 1900s, they pulled apart AT&T. God bless them. They pulled apart AT&T. It not only did that elicit a huge amount of investment, but guess what? We still have two telecommunications companies in the country because they all reconsolidated. So, and everyone who was in favor of all the breakup bemoaned the fact that it was a failure. I don't think that these approaches, I think that I agree with Kara fundamentally that what we need to do is have competition for these guys and allow people to walk with their, to vote with their feet on where they're going to be and how they're going to do things. I think that would be the most fruitful way to do it, to solve this problem, to give people alternatives. My problem is I don't think that any of the tools available to government are useful or forward-looking in any way in order to accomplish.
I mean, I'm talking about them in concert because I think they tend to put all their eggs in the antitrust basket or the tax basket or whatever. There's all kinds of tools. And when you talk about that idea of breakup, look, Microsoft was not the success that the government imagined it would be, but it also slowed down. Well, it was, but it wasn't. But it didn't. They didn't get broken up. They thought at the time when I was covering it. I can't hear you, Christopher. You're on mute. They thought they were going to get broken up when that was the sort of the intent, the idea, and it never happened that way. But it did slow down Microsoft enough for Google to get in a window, for others to grow, Netscape was finished. And by the way, Netscape was finished for all kinds of reasons, not just Microsoft. Let's be clear. As rich as Mark Andreessen is now owning every single startup known to man. And he's done just fine, by the way. It created a window that so many people ran through, including Apple, including many other things, any other companies that created the atmosphere for the current thing. And then they consolidated again. So opening these windows up in competition is more fruitful in lots of ways. And when you think about, I know it sounds crazy, but right now everyone's talking about, I just did an interesting interview with Mariana Mazzucato, who's a big economist. And she was talking about government involvement, just as it was with the internet, space travel, things like that. We've sort of abrogated the government's responsibility to be part of the innovation economy as if they're stupid, when in fact they're not. One of the points she made, which I thought was a great one, was, if you remember President Obama, who I think really did drop the ball on a lot of tech regulation, but nonetheless, he had lent money to Solyndra and some other companies, and everyone was like, "Oh, it's a disaster. The government shouldn't be involved in innovation, this and that." The government also lent $500 million to Elon Musk. It saved that company's ass. It just did. They did it exactly the right time, and then they paid back the government. And Elon Musk is now the richest man on the planet. Whether you agree with the valuation or not, that's besides the point. He's done some amazingly innovative things around cars. But there is a government role here, too, in being involved in the next stage of where we're going with AI, transportation, infrastructure, healthcare, all these things which are going to be drastically impacted by technology. And what's really interesting is the areas that are upcoming. Climate change tech is another area of that. It's going to be huge, vast fortunes created in climate change tech. Each of these areas is very competitive right now, whether it's food, whether it's food innovation, whether it's AI innovation, except AI is now sort of solidifying into a couple of companies. But I'm talking about lots of tools to use it, where the government can be involved in innovation and investment. The government can be involved in taxing and in some regulation, some antitrust. And I think we've sort of created this impossible situation where we think there is one solution to all these different things and all these different companies.
Well, let's just take 1 minute to try and, if we bring back kind of focusing on sort of social media and democracy, that whether or not, let's say, an antitrust response all by itself can work, whether or not sort of breaking up monopolistic actors is durable. Randy's suggesting there's always a kind of reconstituting option downstream, but the style of that intervention is to say, the government's not going to be able to make substantive content decisions that are going to regulate in a space. The government's not going to be able, and frankly, any actual use of a taxing authority is going to have to entail substantive decisions like that on the back end. So instead, the government should just make decisions to try and proliferate the number of actors in a space. Maybe that's through some combination of subsidies for new entrants into the space and breaking up some of the monopolistic actors that have all these barriers to entry that they keep erecting. But if those are means to a solution of the problem of the cacophony and the overwhelming volume of disinformation on social media, et cetera, the presumption is that more players in this space, that one of those players is going to be like, what, better at delivering the truth?
No.
And what does that look like?
So Kara mentions antitrust, and Randy's skeptical. Look, I was at the Justice Department working the Microsoft case when that was happening, and from the inside, I can see antitrust changing in response to some of the things that we're talking about. So, for example, antitrust thinkers they have in their minds, what's the effect of this merger, not just on social welfare, on competition, but on speech, right? They're thinking about the structure of speech markets. So for example, if Facebook were today proposing to buy Instagram, I am mortally certain that whether the antitrust division is run by Republicans or Democrats, that merger would not have been allowed, because people would have looked ahead and said, well, Instagram is the potential player that could dethrone Facebook. So instead of allowing them to buy it, you make them compete. Okay, so where do I think this is going in terms of the speech market? I think you're right, Trevor, that if you fragment the speech market, that doesn't mean that some white knight emerges who kind of fact checks, PolitiFacts everybody to death and corrects bad speech, because I actually think correcting bad speech is really difficult. I think what happens is that none of these players are able to ignite the kind of bubble around some piece of disinformation that makes spending money on spreading the disinformation worth it. So I think to some degree, market fragmentation disarms disinformation partly by making bubbles harder to inflate. That's all it does. I think at the end of the day, and this is what I alluded to in the beginning, we're not going to solve this by kind of tinkering with the structure of markets or tinkering with our rules. The only way we're going to solve this, I think, in the end, is by building a society that I think is more equal and more just, and that will release some of these pressures that I think are working their way out through our so-called speech markets right now.
That's really
yeah.
I mean, I think that's absolutely right. And it indicates that we might be having too narrow a view when we think about this legal framework or that legal framework or this combination of legal measures. We need to think about the way in which social movements and social convulsions can be animated by, feel like, social equivalence of constitutional principles. So, for example, in the debate about campus speech, which has been flaring up now for 20 years,
God.
and it's a terrible debate. One of the things about it is that it's animated by the idea of we have a social principle here of free speech, and that people need to be governed by that, whether they are formally governed by the First Amendment or not. And then the debate flares up about the proper function of a university or the proper function of speech on a university, the relationship between the educational mission and vigorous engagement with others' points of view. All of that is taking place really outside the idea of a legal framework, all of which is taking place that we need to develop some strong social sentiments, strongly felt in the community. And I mean, goodness me, I'm going to show my academic credentials now by saying once upon a time there was a man called John Stuart Mill, and he thought the problem here was social, not legal. It was that society has to find ways of tolerating free speech. Society has to find ways of genuine democratic engagement. And the role that law is playing is mostly just to the shreds and remnants of persecution, reinforcing the social ban. So conversely, it's possible to think about not just a society of justice and equality, as Chris mentioned, but a society genuinely committed to engagement and therefore providing a different environment in which social media would operate. Now, whether this is anything other than a utopian gesture, I don't know. But
Jeremy, I think the problem you have is most of these new technologies people don't see it systemically. They're addictive. They're 100% addictive. They are necessary to do your job. So you can't not be part of them, right? If you really want to be part of a higher level of, the better earners of society. So it's addictive, necessary. It is so easy for malevolent players to use these. And that's really what's very, very different is they can enter the picture secretly and with all kinds of, like, I used to joke that the Russians were customers of Facebook. They were customers. They're like, they just use the system as it's built. And then it's in the backdrop of increasingly, and this is not a new thing, the information diet of Americans and across the world has gone down considerably, the way our regular diet has gone down in ways that we with sugar or whatever. And so you've got all these things sort of coming together in a systemic way that's crawling down people's brain stems. It's also really great stuff. I mean, when you say, if you had to believe, you like Biden or you don't like Biden, but wait a second, he's an AI robot, and that's why he wears a mask. That's the latest one, by the way. The reason he wears a mask is because the AI isn't complete on his lips. It's a lot more interesting to think that Bill Gates is injecting you with a chip. These things have a believability and an ability to sort of crawl down human brain stems and go to their worst qualities. And so when you combine it all together, you can't, I have empathy for the people who attack the Capitol. I have no sympathy. I think many of them should go to jail. But the empathy is that they truly believed it because they've been radicalized and read these things over and over and over again, that they have no ability to be civil at some level. It's irresistible. It's like sugar or something. And so that's my worry, is that there's no legal thing or a state thing that can fix this in a way because of the combination.
I see that Chris wants in, but I want Faiza to be able to jump in here too. She's been so Faiza.
Yeah, I mean, I think you're right about all of that. At the same time, I think that there is, when you look at what happened at the Capitol, you're looking at political violence, right? And you can talk about the means by which, people came to their views, et cetera, but at the end of the day, it's an issue of violence, but it's also an issue of political disagreement. And I don't think that I think one of the problems with focusing too much on social media is that we forget about the underlying issues, and really it gives us a way to kind of ignore that stuff. And the reality is that whether you like it or not, roughly a little bit less than half the country, thinks that, we should have voted for Trump, right? And I just don't see how you can just blame everything on social media. I think you can blame a lot on it, and I think it sort of magnifies and exacerbates underlying dynamics. But the underlying dynamics, I think, are what we need to be focusing on.
I think that's where Chris was before. Chris, do you want to jump in here?
Yeah, I mean, look, if we were in the 15th century or the 14th century and we were having this conversation, we'd be talking about Prester John, right? Who was a Christian patriarch who was said to live somewhere in the Orient, be surrounded by angry Muslims. He ruled over this, legendary kingdom. And, people went around Europe agitating for a holy war to go like rescue Prester John. So this was insane, right? But people always have some set of insane things that they believe. And the only question is, how do these insane things work their way out? And does society as a whole have a way of preventing these insane things from kind of maturing into political action? We've talked about social media the whole time, but we haven't talked about the fact that our political institutions are in a parlous state, right? We have, one party seizing control of the judiciary to have the judiciary enact their, agenda. We have another party kind of pushing back. We have a government that is not resisting these currents in the way that it used to, right? In part, that's the breakdown of elite control, but in part, I think there's something more, right? There's like the breakdown of the idea that democracy is effective.
That's interesting. So you're leading us in the direction of whether it's not social media that might break democracy, but democracy that might break democracy?
No, democracy is in the process of potentially breaking the internet. And, is democracy breaking itself, I think is the broader question. I totally get that we always want to isolate like what's changed, right? What's changed that makes our current moment so difficult? And, what's changed obviously is we have this enormous communication facility at our fingertips, all of us, not on equal terms, but on terms that are much more equal than they were in the past. And I think like any huge transformation in human life, there's good and there's bad that comes out of that. I think we examine that, maybe over-examine it. I think what is underneath, though, are currents about like democratic self-governance that go beyond that. And we're not really touching those.
So social media doesn't kill people, people kill people. Is that really?
So the addiction thing. So for example,
it's a huge deal with these devices.
So the question about addiction, like social media is great, but I remember, like, I'm old enough to remember that, when I was a kid, people were telling me that video games are addictive. And
Yeah.
that I was, and the truth is they're no more addictive.
Those were one way. These are two way and responsive. There's a whole new level of thing that's going on here with communications. But you can argue, yes, people are terrible at the heart, is what you're saying. Essentially,
the addiction trope is like it comes up again and again. And I remember this thing I said to my kid. When my son, my oldest kid, was young, I talked to him a little bit about pornography, and I said to him, pornography isn't real sex. And he said to me, he's like, what kind of idiot do you think I am? Of course I realize pornography isn't real sex, just like video games isn't real life. I get you, but addiction, I think, is I'm skeptical of that trope.
We've got about 10 minutes left. Randy, I think you were raising your hand earlier. We've had a number of great questions from the audience that I'm looking for opportunities to fold in, but I saw you raising your hand.
No. Why don't you go ahead with the questions? I think that the horse may be beaten pretty severely at this point.
One thing that is sort of lying behind a number of the audience questions I've seen, I think, is what could we possibly do that would make things less bad? Like, so there's, many of the things that Jeremy said about, the underlying requisite here would be some kind of set of social shared norms. That's a difficult enough conversation to have within a university, but for an entire society or globe, it seems optimistic, let me put it that way, charitably. So that's one kind of thing. We'd hope for that, a broader social consensus around a set of norms that we see not being observed. Another that Kara's put on the table is, look, at least break up these monopolistic actors, hoping that more players will create more different options.
And then we'll have to do it again. It's like
Yeah.
mold. It's just, it doesn't matter if it doesn't work. It works for a while, right?
So assuming that the criterion for success is not completely solving the problem, but maybe mitigating some of the worst aspects of it, Randy seems to me maybe most skeptical of our panel of the prospects of legal interventions to make things.
No,
less
I
bad.
actually think there's one thing that we should do.
Okay.
So I'm actually against the notion that we need to have a panacea. It's part of the problem with cybersecurity and privacy legislation is that everyone seems to think that some bill has to solve every problem in order to be enacted. And that seems to me to be very wrong-headed. So I do think that I liken Section 230 to Henry Ford coming into Congress around in the teens or the late teens, sort of saying, "Hey, Congress, I got this great idea. I'm going to make a product that is going to absolutely transform America," which it did, absolutely transform America. But you know, this McPherson v. Buick decision that holds me liable for people running, you know, for when the wheel falls off, which happens every once in a while, is ludicrous. You got to protect me. And Congress saying, you know, Henry, you're absolutely right. You have immunity from those lawsuits. That would have been a disastrous decision. And we've seen some disaster coming from this decision to immunize these platforms. My own view is that the various bills that carve away protections to allow private lawsuits against the platforms more often to be successful will have a salutary effect. And at the very least, we ought to see what happens if it starts doing that. You know, if we come up with different allowances for individuals to hold them responsible in various areas, maybe retaining the essence of a protection for defamation type claims, but beyond that, sort of saying, hey, you know, the title of the section, which is to protect Good Samaritans, actually means something. And, you know, this is not a new idea with me. A lot of people have actually pointed to that title and said that it should mean something because it wasn't added by the folks putting it into the USC. It was actually Congress decided that was the title. You know, we should think about some of those solutions while we're waiting for the Jeremy's, you know, wonderful coming of a social compact. Maybe we should take some baby steps and see what happens. We can operate a little bit we've had the A-B testing is what happens all the time in technology. We've had the A. Let's do the B testing for a little while and see what some private lawsuits, some opening up of the genius of the American litigator will do to change things a little bit. I'm not sure what'll happen. I don't think the internet will fall apart if that happens. And we can course correct after the next 25 years and see if things are a little better.
Faiza,
Yeah, liability is really important. Some more level of liability. Nothing like a lawyer to clean up and mess up, you know.
music to a law school dean's.
Not all lawyers,
but
just the good ones.
Faiza, do you want to weigh in on thinking about the particular concerns that you outlined at the beginning? Do those concerns lend, in your mind, themselves to a particular kind of solution, including doing nothing, because maybe any attempted cure would be worse?
Well, I mean, I think I really like the idea of a privacy legislation, but that may be just because I like the idea of privacy legislation more than I think that it will fix anything. I am concerned, again, you know, because we don't have enough information about who is impacted by takedowns and content moderation generally. We have our suspicions. We have, you know, a few anecdotes here and there. So I think that, you know, any sort of changes in the liability regime must be accompanied by some kind of mandatory disclosure requirements for at least the larger platforms. The other thing that we've been sort of noodling about, and I don't know where I come out on this, I'll just throw this out, is, you know, the approach that platforms have taken to content moderation is they moderate at scale, right? So they're looking at, you know, these billions and billions of pieces of content in some way, shape, or form, and they're trying to use AI and all of that. And maybe that's sort of like backwards. Maybe what they should be looking really closely at is at the high reach accounts, and be really focused on the idea that, and there is, I think, research out there that supports this, and maybe it's not enough, that, you know, that the sources of sort of, whether it's disinformation or, like, you know, really sort of, it's I don't know who said this, but this idea that you can sort of, this power of disinformation and sort of spreading out and being really a good vector, like those are the high reach accounts, right? You know, how much more peaceful has life been since Donald Trump was kicked off Twitter, at least for me, I'll say. But whether there is maybe some way of thinking about that. And I understand, obviously, that has huge First Amendment implications when you are actually, censoring the most powerful voices in the world.
There's 12 things on Facebook around anti-vax. They've identified 12 vectors that are the most important. Just
the people, you mean, or accounts?
Accounts, people, things like that. Yeah.
So
built in the most damage
of,
that have the most influence.
Faiza, it's like I hear you raising something like almost the opposite of the public figure doctrine in existing.
Exactly. Yeah.
Being a high vector, which is analog to a public figure, would bring with it a responsibility that these platforms at least might impose.
I have one more thing that I think is really interesting. If you've noticed, a lot of the tech companies have suddenly started releasing more data. YouTube just did this around hate speech, around their impact. I forget, it's VVR, I just talked about it. They used to just release how many takedowns, which is a meaningless number. Like, it doesn't tell you how many were up there. It doesn't tell you how many were close to it. But now they have the impact of the ones they take down, which is how many people watched it, et cetera, and where did it go, and stuff like that. My feeling, thanks for the data, but why don't we let independent researchers, academics in there and into that data so we can all decide where we're just relying on them to tell us what works and what doesn't. And of course, they're always going to do things in their self-interest. I don't mind. That's what they do. So getting more access to the data so that we understand it, whether it's the government, whether it's independent academics, to understand, we can't do we invented the internet, government invented the internet, so let us in. But there is some way to get more information that's meaningful, because we are at the mercy of these companies telling us meaningless data about everything they do, usually for a PR thing. And then my only other second solution to any of this, and I think there is, and I agree with Randy, it's really hard, except for little small things like liability and different laws and things like that, would be aliens. Like aliens coming down and finally figuring it out for us. That's my only, at this point, that's what I'm saying to everybody. I'm like, the aliens are going to get here and they're going to just clean it all up. I feel like, and then they're going to eat us, like to serve man. Like, they'll make us all peaceful, and then they'll.
Jeremy, you've been outflanked in your optimism on that one, but
I'll stick with John Stuart Mill, not the aliens.
Aliens, I'm telling you.
John Stuart Mill was an alien.
A lot of tech people think this is all a simulation, by the way. A lot of big tech people, including Elon Musk, think this entire world is and Trump is only because some teenagers of the future have decided to fuck with us. That's his whole thing. But that's a whole nother discussion.
Would explain a lot. We've got just a couple minutes left. Randy, I think I saw your hand up. Did you want to give one last thought here?
I feel like I only have to push back a little bit on Chris and Faiza on the notion that the notion of one-sided content moderation is a fallacy. I think that there's no way in God's green earth that the humans that are deciding content moderation are doing it in an unbiased fashion. And whether regardless of the political notions, things like the public TV interviews of Justice Thomas disappearing off YouTube, the discussion with PhDs and MDs and that hated Governor DeSantis about the cost benefit of the government's response to the pandemic being taken off YouTube. That's a disturbing thing. And whether you just want to talk about the orthodoxy or not, I think that heterodox views have, in certain instances, have become okay to take out. And this is occurring in a lot of places. And if you have Amazon deciding certain books are not going to be available because they challenge the orthodox view on items, that's a problem when they have successfully destroyed the neighborhood bookstore over the last 20 years.
So I don't disagree that, there's the potential when there's market concentration for suppression of viewpoints, and that we have to worry about that. this is why I think, antitrust intervention would have been a good idea and still is a good idea going forward. I also agree with your baby steps perspective. My baby step might be a little bit different. The Warner legislation, what is it called? The SAFE Act has a piece in it that says, well, shouldn't we treat content that Facebook or others are getting paid for differently than content that comes from you or me, right? Just our posts. And the language, I think, is potentially a little bit loose, but with a little bit of work, it might be that Facebook is required to do more work to screen advertising material. That might be a place to start, because of course a lot of disinformation comes through targeted ads. One other thing I would note, then this comes from copyright law, which is kind of my playground. Copyright law has safe harbors for online service providers. So YouTube, someone puts up a video on YouTube and someone says, hey, that's my content. They send a takedown notice to YouTube. YouTube takes it down. The person who put it up can send a counter notification saying why they put it up. Something like this notice and takedown procedure with enough protections built in and narrowly crafted enough to certain speech that is characterizable as defamation or characterizable as harassing might be, if guided by law, might have more teeth and might be a good place to start thinking about this.
And that in fact is the PACT Act, part of the PACT Act that Schatz and Thune presented and is in the Congress now, has a modified notice and takedown, although it does not have as a robust response notion as that. I would note that Section 230 absolutists glory in the fact that there is no notice and takedown aspect of Section 230 because they fear the trolls who will, the heckler's veto is.
And rightly so, right? Because we see that in the copyright context.
Right. So we have penalties, for example, in the Copyright Act for trolls. The courts have eviscerated these penalties. They never enforce them.
Right.
We have to tell the courts, hey, we mean it, right? When trolling happens here, we need to have punishments. And, I am tentative about this. I think this is something we should look at because I'm not an absolutist on 230, although I'm very cautious.
I think that there are a lot of interesting ideas in the various bills that have been put up. There are a lot of problems with them. But again, I think part of the problem is that if you regard Section 230 as a sacred cow, we will not move forward at all on these aspects. We have to approach it as an enactment that had a purpose, as Kara said 25 years ago. Maybe that purpose has been outlived and we ought to take a more rounded view about its pros and cons and slice some parts of it off.
One of the things about this issue is we could go on talking about it for days. I, in a sense, wish we could, but we've reached the limit of our time. And I just want to thank all of you and the audience for joining us. I think we've covered a lot of ground in the last 90 minutes. And I'm really grateful to each of you, Kara, Faiza, Chris, Jeremy, and Randy, for your tremendous insights. I hope members of Congress were listening and that they'll contemplate some of these baby steps. But I also hope that we can continue to think about ways beyond law to achieve the sort of set of social norms that Jeremy has referenced. And it does seem that the fraying of society that Chris referred to at the beginning is some big part of why we are where we are in the social media space. And the question of what we can do about that in the long run is a big and deep question. Without having solved it here today, we've at least laid out some important arguments to think about. So I'm grateful to each of you and grateful to our audience for joining us. Thank you very much.
Thank you, Trevor.
Thank you.
Thanks, everybody.
Thank you.
Thanks.
Thank you.